Well, hello out there. This is Decent for We the People News. I thought I'd bring up a little news that I just came across while I was chilling, watching a little bit of YouTube. Even with my YouTube, I still learn. This is the reason why I watched this young lady here. She's younger than I am. I call her a young lady. Alright, Chris Ann Hall. Once again, I'm not an attorney. Don't claim to be an attorney. This is just in the process of teaching so we can stop looking straight forward and always look around, for the outside forces may commit harm upon you, especially government officials. And this court case really kind of just ties into this. Now, what you hear from her, and she don't bring it up, but take everything with a grain of salt. I mean, we all know that officers sometimes shoot first and ask questions later. So understand and pay attention to the demeanor of officers at times, and realize how far you can and cannot go. Alrighty. If you happen to ever get an attorney, you may want to bring this up to the attorney if you end up going to sue or whatever. Again, it's not legal advice or anything like that. Whatever I say is just with a grain of salt, and always verify with the attorney. Wink, wink, wink. Alright, here we go.
All right, I have a court story for you today. You might be seeing that. You might not be seeing that, but I wanted to share it with you. There we go. Georgia. So Georgia has come out with a Georgia court opinion that it's lawful to use force to resist an unlawful arrest. Christopher Glenn insisted he was doing nothing wrong. So when the Athens-Clarke County police officers handcuffed him and took him into a patrol car, he was having none of it. Kicking and flailing, he strongly resisted. At one point, Glenn lunged forward, smacking a sergeant in the face with his forehead. Soon after that, he was lying atop another officer on the pavement, and when officers finally got Glenn into the cruiser, he kicked at the door so violently he damaged the hinges. Well, it turns out the officers had no probable cause to actually arrest Glenn for loitering and prowling outside the Oglethorpe Elementary School in Athens. And his appeal of the incident has led to a landmark Georgia Supreme Court case where the court held on a centuries-old case from England to find that not only was Glenn within his right to use force to resist the unlawful arrest, he could also damage government property to do so.
Who wrote this?
Who wrote this? The Atlanta Journal-Constitution.
Oh.
Why do you ask?
Because those are strange statements in that article, knowing what I know.
Mm-hmm. So tell us what you know.
Well, they're calling it landmark. That makes it sound like it's something new.
Yes.
And then they say it's based on, they seem to emphasize, a centuries old, like they dug up some ancient thing from some other country to come up with it.
Yeah.
This opinion has been issued, I think, several times, pretty well settled at the Supreme Court as far as court cases go. So I don't know who would be writing this or why they would not inform themselves.
Well, I think, to me, it was an effort to sensationalize what was actually happening, to make a story out of something that's actually precedent established, which begins in a Supreme Court case from 1900, not an English case, but actually a U.S. Supreme Court case called Bad Elk v. United States, and it's from 1900. And there's been precedent since then that has relied on Bad Elk, but Bad Elk is the standing precedent.
The reason why I paused it, I actually knew about this case. And I knew that there's certain things you can do. I just forgot what the case was. And I didn't know how many cases after that. I just knew about this one case, and I knew about the case in England. But I didn't know about a few other ones after this, and really still don't. I just knew about this elk and then the England, which what she would describe English law, common law, which is what our common law is based off of English law. Anyway, we'll proceed forward.
That continues. And in Bad Elk, constitutional attorneys learn this, and I think most law schools even teach this still as well. But in this case, you have two tribal police officers who are trying to arrest a man named John Bad Elk. Well, the one tribal police officer recognizes that the other tribal police officer is committing an unlawful arrest and tries to make him stop. Well, then the one tribal police officer ends up shooting the other tribal police officer to save John Bad Elk from being arrested. And the Supreme Court of the United States held that it is lawful to resist an unlawful arrest with force. Now, if you end up killing someone, you're not, the murder may be reduced to manslaughter. So you're still going to be held accountable for killing someone. But if the arrest is unlawful, you are authorized, according to the Supreme Court, to resist that arrest with force. And that is what has that actually comes from English common law. But nonetheless, most of our law comes from English common law. For this case, for this story to be sort of run the way it is, like it's some kind of big deal, I had to pull this up because, like you, JC, I knew about the Bad Elk case. I believe we've actually even had conversations about the Bad Elk case here in the house. And I thought to myself, reading this, what is the agenda here? What is exactly is the agenda? Because
the Atlanta Journal Constitution is very leftist, so it is because this sounds pro-police to me, which is strange for the Atlanta Journal Constitution to sound like that. So I don't. I guess an individual journalist could write whatever, and editor passes it. I really don't know.
Unless they're trying to claim that Antifa and those guys.
That's true, yeah.
See, I thought that's what ran in my head. They're trying to build the case for. These are the same people that are defund the police, right?
Yeah,
and they're trying to justify violence against officers.
Well, obviously, but I'm saying they sounded like they were criticizing the opinion, is what it sounded like to me. Maybe I just didn't. Maybe I'm just hearing it the wrong way.
Oh, because they were talking about it being a centuries-old case and digging it up kind of thing.
Yeah, maybe it's not intended that way. Maybe it's like you're saying they're trying to emphasize that it's okay to attack police.
Yeah,
maybe that's what they're trying to say.
I think that it's just amazing to.
But it is what it is. It's been that it's nothing new.
Yeah.
It's not a landmark case.
It is not landmark. It doesn't change anything. As a matter of fact, I thought it was interesting. It said a landmark case that relied on centuries-old cases. Isn't that sort of contradictory? If it's landmark, then there isn't anything before it.
So
it's just
resist and unlock.
Just want to remind y'all right quick. The reason why we're allowed to bear arms is to protect ourselves from tyranny from the government. That is the whole reason, And if we are allowed to protect ourselves from the government, then we are allowed to protect ourselves from criminals may enter your house or whatever, or want to cause you harm, foreign invaders. But the reason why we can't be able to bear arms is to protect ourselves against tyranny of the government.
Awful arrest with force.
With force.
That's pretty
Yes.
much what the Supreme Court has held. And so here, basically the story is the Georgia Supreme Court aligns with the U.S. Supreme Court and gave basically the same opinion as the U.S. Supreme Court has given previously.
And the same decision that federal courts have been upholding since 1900.
Right.
So
well, there you go.
There you go. You know, nothing to see here, move on. But again, I just have to believe that there's some kind of an agenda here, and I'm going to start watching. Are there going to be a lot more? I mean, is this going to be picked up by the national news? You know, and are they going to carry the whole, this is novel, this is landmark, guess what? You can go out and you know, shoot people with impunity. So, I don't know.
What's funny about this, y'all? It's kind of like the no-knock warrant. You're still allowed to protect yourself. So, you know, people going to court and fighting this in court because they picked the wrong house and, you know, somebody accidentally shot it. Well, accidentally, my foot. Accidentally shot a cop or a sheriff or undercover agency, you know. When they thought it was just a bad guy, regular bad guy. They shouldn't even have to go to court in the first place. And I haven't kept up on the ones here in Texas, but this has been known to happen in Texas. And of course, YouTube, if you guys know about this happened in other places. But these cases, and again, I have to stress that I only know about elk. And this one here, I just assumed there was more of them. I just never researched them. But if your attorney is a really good attorney, should be pulling up all these cases and putting it into courts to uphold your rights of pretty much self-protection. I mean, it wasn't a no-knock warrant. Wrong house was an unlawful warrant. So it was an unlawful arrest. Some of y'all have seen the one with the lady, you know, and have her clothes, you know, didn't have time to get her clothes on and all that kind of stuff. Again, she is allowed to do what she do to protect herself. And her attorney should be using these cases. Of course, she didn't attack them or anything, but again, if we start bringing up these cases darn near every time it happens, you know, it'd be just so full of case log about this, they would have no choice but to cancel no-knock warrants. Now, Kansas did a very good job and actually did that. So that got passed not too long ago. So yay on Kansas on that. I'll finish this little piece right here and end it.
I don't know. That's just the thing. So this is a very interesting...
Okay, well, that wasn't much more. So, for we the people, there's another basically case added to protecting yourself from unlawful arrest. But, fair warning, if you decide to push this, pay attention, always pay attention to the officers. Some of them out there may just want to go ahead and shoot first, ask questions later. So be real careful when you do it, but challenge it as far as you think you can do it safely. Alright, this is Diesel for We the People News. Bye, y'all.